special meeting of the Belleville Zoning Board of Adjustment for August 20th, 2019 will now come to order. Clerk, call the roll.
Bennett. Here. Caruso.
Here.
Giordano. Lopez.
Here.
Losaw. Catalino.
Here.
Sheldon.
Here.
Milano.
Here.
Del Garcia.
Here. Will everyone please stand for the Pledge of Allegiance? I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Secretary, has notice of this meeting been given in accordance with the Sunshine Law?
Certification of the meeting has been advertised according to the Sunshine Law.
Okay. We're not going to do any minutes tonight, any applications for adjournment tonight, unless Mr. Gassion wants to adjourn, and no resolutions or communications, I believe, tonight. What is this communication? That's communication? Okay, there is one communication. Our secretary, am I right, Miss Ciccarelli. I don't want to mispronounce the name. Okay, you did receive these packets from someone in the police department, am I correct?
Correct.
Correct. We're going to give these packets out at the end of the meeting. These are for incidents involving 120. It may be incidents, may not. I'm not sure. We're going to have to get somebody to tell us what certain things mean. But it's for incidents at 125 Academy. And me and Mr. Rago have agreed that he's going to have a copy, you're going to get a copy, and Mr. Gassion's going to get a copy. So we can discuss this on the next meeting. We're not going to discuss this tonight. Okay? And Ms. Gina is going to make copies for all our members, and that's going to be given to us in our packet for September. Okay, gentlemen? And lady? Okay.
If I could make one comment, I want to remind Tom Herrick, Frank Lorenzo, and Ed Colling that you were sworn in on the at the June 6th meeting, and you're still under oath.
Okay. We should have sworn in Gina too, because she gave us the statement. No, not necessarily. All right then. We will proceed. Mr. Gassion. Where we left off the last time we were here, we were going to get some testimony, I believe, from one of the priests. Because a question came up that was brought up by Mr. Shelton about your architect bringing up the 4 properties. And Mr. Shelton had some questions, and I thought the priest was going to answer those questions.
What I indicated was that that property was not before the board and not a part of the application. However, my planner will comment on it and try to answer Mr. Shelton's question.
I believe we want the priest to testify.
Well, the priest had a commitment tonight. He could not
Well,
be.
then he'll be at the September meeting.
I was hoping there wouldn't be a September meeting.
Well, I don't know about that.
Until you just brought up a police report that we have not yet seen.
Exactly. So now you know there's going to be a September meeting.
You're requiring it.
Requiring it because this is evidence that members have asked for, some members have asked for, and members of the public have alluded to. So because of that, we want to go over this as part of the case. Plus, Mr. Shelton has some questions involving the property, the 4th property, maybe even the other properties, I don't know. But the thing is, I think we can get direct testimony from the priest, so I would ask the priest to come to the next meeting. Okay? Okay, now you may proceed. I assume tonight you're calling your plan.
I am.
Thank you.
Mr. Chairman, members of the board, as you know, I represent the applicant in this matter, St. Mary and St. Mercurius Coptic Church. My clients own this application that they own properties at 121, 125, 143, 145, and 147 Academy Street. This is the 3rd hearing date. At the first hearing, the board decided that Res Judicata did not apply, and we then proceeded with the application. The witnesses that night were Father Luke Istanafus from St. Mary and St. Mercurius Church, and Beth Kenderdine, the site engineer. Based on board comments about the parking layout, My client's experts made some changes to the site plan and submitted them to the board on or about June 26th of this year. At the second hearing, the site engineer testified about the site changes. Eamon Cedra, the architect, followed her and described the existing structure, reviewed what is being demolished, and discussed the proposed new structure. I'm going slowly because my witness is delayed in coming in.
That's okay, go as slow as you want, it's your time.
Tonight I plan to call my client, who is the planning consultant, my client's planning consultant, and he will discuss the planning reasons and testimony with regard to the history of the property. Also, I do not plan to call any further witnesses unless a rebuttal witness is necessary. So I was prepared to finish the case tonight, subject obviously to what counsel has, I understand, from conversations over the history of this file, that he is a planning consultant who happens to be here and ready to testify. Now, you've introduced a police report, which obviously I need to look at, and so does counsel.
Yes, sir. That's why I'm giving you a copy tonight and him a copy.
Thank you, Mr. Chairman.
You're welcome.
I'm going to need about a 5-minute recess. My witness had an issue with a copier and should be here momentarily.
No problem.
Sorry.
We will have, yes, 5-minute recess. We'll go back into session 7:15.
Thank you.
Yes.
Okay. The regular zoning board, special meeting of the Belleville Zoning Board of Adjustment for August 20th, 2019 is now back into session. Mr. Rego is going to discuss something that may have changed in our zoning laws applying to this case.
All right, and councilors, during the break, our zoning officer made the chairman and I and Ed Colling, who's the township consultant on this, township planning consultant, aware that the zoning, since this application was filed, the zoning may have changed to convert this from a conditional use to a permitted use. Is anyone, I've not seen the ordinance change, nor is Mr. Colling. Is anyone aware of that? I mean, is
No.
Mr. Steck aware of that?
Absolutely, Mr. Steck is aware of it. He was at town hall today checking the ordinance.
Okay. Will that be addressed?
Absolutely.
Well, my position is I came here tonight prepared to cross-examine their planner based upon the application they submitted, the variances they were seeking. If this application is going to be changing in some way, so that it's no longer a conditional use with the panoply of issues that are implicated by that, I should be given reasonable notice of that. You're giving me that now, but there's been no amendment or change to the application. So if this application is going to be converted from a current conditional use application with 5, 6, 7 different bulk variances.
The client is speculating.
Well, I'm sorry,
Counsel is speculating.
please don't interrupt me, and I promise I will not interrupt you. Is that okay? So as I was saying, I believe that we will be prejudiced if now suddenly they're going to have a planner come up and testify that this is now a permitted use. Why didn't they give notice to the board that they were amending the application? Why didn't they give notice to me before I came here tonight and before I prepared all day today to cross-examine based upon the application as it exists right now? That's not fair. That's not reasonable notice.
Well-
So that would fundamentally change the planning testimony.
Well, it may or may not. We all had notice. We've heard this for the first time.
Tonight.
Obviously, we heard this informally from our zoning officer. Mr. Steck's been aware of it. I know, Mr. Lyon, have you been aware of this, or?
No, I have not.
Okay. I think, you heard the chairman earlier. We're not deciding this tonight at all. I think the way we should proceed, it's up to the board. My suggestion would be, let's hear Mr. Steck, let's hear what he has to say. I'm sure there are dimensional variances that still exist. Is that true, Mr. Gassion?
There are.
Bulk variance. Okay. You can cross-examine Mr. Steck to your heart's content on those deficiencies. And when you're done cross-examination, I'm assuming if you want to proceed with Mr. Lyon, not knowing that this may have changed, the ordinance, the application's the same, but the ordinance has changed, and under the law, an applicant gets a benefit if the ordinance change is in favor of the application. The rule that says the ordinance in effect at the time of the filing, that no longer pertains. It's the new ordinance.
But the application has changed if it's a permitted use. The application now is for a conditional use. Because it's a conditional use, it requires, I have all sorts of boards I prepared to cross-examine based upon the conditional use requirements, all of the elements that had to be met. Now I'm hearing, and some of the members of the board as well for the first time, that they no longer are pursuing the conditional use application, but it's a new application in my judgment, because whatever Mr. Steck is about to say tonight is not going to address the application for a conditional use. His position now is going to be apparently it's a permitted use. They have an obligation to notify us, to notify the public, so we have reasonable notice of that. So I can now, instead of spending the last 2 days with my expert, preparing to address the conditional use application, we now come here tonight and it's a completely new application in terms of the legal elements from a planning perspective. Council, as you well know, under the conditional use ordinance, there are a variety of different things that have to be shown. Ensure conformity with bulk requirements, no detriment to surrounding area. There's a whole litany of things I was prepared to cross-examine on tonight. Now apparently I've wasted my time, because we weren't given notice of the fact that they were changing their application, which they knew about before today. And I feel like I've been sandbagged here. I spent 2 days getting ready for this when they knew they were going to change the application tonight.
We don't know that. The application's the same, except now it appears to be permitted, but there's still variances involved. Again, we don't know what Mr. Steck is going to say. We don't know what Mr. Gastione is going to say. We're in a vacuum. In my view, it's up to the board. In my view, Mr. Steck should be heard. You're not going to be prejudiced, because you could say at the end of Mr. Steck's testimony, I'm not prepared to cross-examine him on this new testimony.
I'm telling you now I can't. I spent all day today, half of the day yesterday, preparing to cross-examine Mr. Steck based upon the conditional use application that's before this board. Now I'm being told it's no longer a conditional use, which means that the planning and legal elements that have to be established have now been changed. I had a right to know about that before I walked in here today. And so I can't cross-examine this gentleman if he's now going to give testimony concerning no longer a conditional use, but a permitted use application, nor can I bring my planner on. I'm prepared to present his testimony based upon the elements of a conditional use application.
All right.
I can't do that.
Why don't we do this? And this is only a recommendation. Why don't he give his testimony, and he has to come back to the next meeting for you to cross-examine?
Well,
When you have all the testimony, you can prepare about all the testimony.
Mr. Chairman, I absolutely
that should
refuse
take
to put him
place.
on and then have counsel have a month to prepare to cross-examine my witness.
The only other alternative is to adjourn the meeting and go to next month.
What should have happened is
Can I be heard at all?
Yes,
council
you
could
can be
have told
heard.
me. You could have told me.
First thing is-
Our own expert don't know nothing about this. And that's our expert, the board's expert.
First thing is, my expert happened to go to town hall and find out about the change. That's how he determined it.
Today? Because you said he went
That,
there today.
he was there today. That's
That's my
correct.
point.
Did he find out today? I don't know the answer.
We asked when he found
But
out.
today. Can I
He's
talk
not-
for
he's
2
not
minutes? You
sworn
said
in
you
yet.
weren't gonna
I'm asking
interrupt.
through the board.
You said you weren't gonna interrupt.
Speak, go ahead.
Yeah.
Now, the board doesn't even know, neither does council know what our legal position is after finding that out. In addition, this is a special meeting. Further, at the first meeting, I'm sure the board recalls, that council came in and surprised me with 2 different issues without warning me in any way whatsoever. So how would I ever have an obligation to advise him what I knew after he did what he did in the first meeting?
Because you're changing your application, that's why. Because you're now making it a permitted use.
You don't know
rather
what
than-
I'm doing.
Well, okay, so
He's not
if
making
he-
it a permitted
Well,
use.
let me ask-
It may be a permitted
so if
use
he's
by
telling
law.
me that
Why
there-
the town changed their ordinance, that's what happened, recently, very recently. Actually, it didn't go into effect, I believe, until after the last time we were heard here.
I have no idea when it went
Am I correct?
July 29th. I think the council passed it on the 9th and 28th.
When did it take effect?
I believe the 29th.
Of July.
Yes.
So technically, the last time we heard you was at the beginning of July, I believe. And therefore, it didn't take effect until after this last hearing we had.
Well, it's a new, if it's a permitted use, it's a different application. It involves different planning and legal elements. There's no dispute about that. And so at minimum, Mr. Chairman, I should not be required to cross-examine him tonight after spending a day and a half getting ready to cross him on the conditional use elements of the planning application before you.
He does have a point, Mr. Gassion.
The conditional use element is, in essence, can this application be granted given the conditional deficiency? And can the site still function appropriately given the conditional deficiency? That's kind of it.
No, it's not.
Yes, it
Respectfully.
is.
Here's the ordinance. There's a conditional use ordinance.
Yes.
Okay, so if you're now telling me that this is a permitted use, so the planning testimony now doesn't have to address the elements of the conditional use requirements of the ordinance. It has to address other elements. There are some variances that are being sought, so under the traditional variance analysis, positive, negative criteria, but the point is that the conditional use elements of this ordinance impose additional obligations. When we did this application the last time, we went through this. Mr. Steck testified in great detail regarding the elements of the conditional use ordinance. Section 23-8, I have his testimony all here. I reread it, I'm prepared to cross-examine him on it. Now, all that's out the window. All of it.
Let me ask a question. I want to try and resolve.
Sure, hold on one second.
Go ahead.
Please. You were prepared to cross-examine Mr. Steck on the dimensional variances, the bulk variances, correct?
On the conditional use requirement, there's two separate aspects of this. Aspect number one is the local Belleville ordinance says, if it's not a permitted use, it's a conditional use. And when it's a conditional use, it has to meet these requirements of our conditional use ordinance. That's analysis one. Then if he can establish those elements of the conditional use ordinance, he then still must present testimony concerning variances, deviations, bulk requirements.
But he meets all the conditions, he's in front of a different board. He's not here. He didn't meet all the conditions of the conditional use requirements prior to what we just found out.
Right.
Okay.
I agree. And so that's why he's coming here tonight before this change, and he would testify as to why they are entitled to be approved as a permitted conditional use. Now, with the passage of a new ordinance, apparently they're going to take the position, I'm sure, that it's not necessary to meet those conditional use requirements of the ordinance, because it's not a conditional use. So therefore, it's permitted use. Now we're seeking variances, and now they have to establish entitlement to various bulk variances. But it's a different analysis than the one that I came here tonight. It's a different analysis than what he testified to at the last hearing when they sought a conditional use. I should have been given notice of that since they knew about it.
Mr. Gassion, are you in front of the right board now? If this is a permitted use?
That's the issue, the legal issue, Councilor. Absolutely the legal issue. I don't have to accept the change. I can proceed under the old variance, the old law federal.
What would you like to do?
Well, now that everybody's talking, I need 2 minutes to talk to my client.
That is a good idea.
That's a novel position.
But also, I want to ask one more question before we go into recess for you to do.
I have done that already
Oh,
in this town on another matter
yes.
because of the change.
Last month. Not even, the beginning of this month.
Well, that was...
You weren't
that
here, you
was
didn't
his
know about
third-
that. But I just want to get one thing clear. Am I correct, and I might be wrong, but I want to clear it up, that this is no longer a D application?
I didn't say that.
I'm just asking.
I didn't
No,
say
I'm asking under the new law.
Under the new law...
Under the new law.
Maybe,
our
no.
attorney. Don't ask him, ask our attorney.
Maybe if what we're hearing is accurate, if it's permitted, then there's no use. then there's no use variance involved if it's permitted, but there are bulk variances.
Right.
And there's preliminary and final site plan approval. And
Wait,
reverse
let
subdivision on this one too?
Frankie answer.
Reverse.
And a reverse subdivision.
Yeah, let's Frankie answer.
Take a 5-minute break.
Take a 5-minute
Yes,
break?
take a
All right,
5-minute
let's take another 5-minute break. This special meeting of the Belleville Zoning Board of Adjustment for August 20th, 2019 will now come back to order for the third time. And we had a big discussion up here. Mr. Rego will give you what he thinks we
Well,
should do.
I first want to find out where we're,
Well,
let me hear from both of you as to what your thoughts are on this.
Yes, sir.
before
Thank
we
you very
make a
much.
decision.
So, my thought is this, I would like to make an application to this board now, that we adjourn this proceeding, and we sort out this issue of what the impact is of the adoption of this new ordinance. Frankly, some of you just learned about it a few moments ago, so did I. I'm not certain that that allows this board to even have jurisdiction over this application, because if it is now a permitted use, and is to be considered as such in the context of this proceeding, this board may not have jurisdiction. We need to sort the issue out. I'd like an opportunity to present a legal memorandum to your council, and that way we can vet the issue so we have a full and complete record, and you can make an informed and intelligent decision. That's what I think is the most appropriate way to proceed. Frankly, if I'd known about this in advance of this meeting, I would have written to you and suggested that very thing, but we're here now, and that's my application.
Okay, so the original opinion of my planner and I was to go forward under the application as filed, which we have the right to do, and go forward with the conditional use application. However, based on all that is going on, we need the adjournment and agree with council, because obviously our reason for potentially going forward with the application was a matter of where we are at this time. My client has gone forward for many months with this case. We have the right, in my opinion, based on the new law, to withdraw the application and appear before the planning board. This board, as council and I happen to agree in that situation, if we don't proceed under the original application, we can go to the planning board where the use is permitted. We can't proceed here as if the use is permitted, but I want to make sure everybody understands the distinction. In my opinion and my planner's opinion, we had the right to act under the law at the time of the application and proceed with a conditional use application, which was the preliminary thinking of my planner and myself as to how we were going to proceed tonight. We weren't about to surprise anybody and try to say the use is permitted, because then we would eliminate jurisdiction before this board. So now, with all the issues, I would agree with an adjournment on one basis. I don't think it's fair under this scenario for my client to have paid the amount of money they have paid for a special meeting when the zoning law was changed, and as an accommodation to the board and opposing counsel, we're willing to adjourn the matter. I don't think that's fair at all. So I'd like to have that issue be addressed in some manner, shape, form, or another. I want to go on record with that.
You mean in terms of a refund of sorts, or?
Some credit for, you're talking $3,500 to come here and adjourn the case.
I think you would have to request that from the council. I don't think you can request that from the board. We still had this hearing tonight. Our experts are still here tonight. They still have to get paid. The attorney, the transcriber, and Ms. Ciccolelli, they all have to get paid for tonight. Now, if you want to get a reimbursement, you could request a reimbursement based upon the council who caused all this mess by approving this change in the ordinance, and you can get a refund from them. But I can tell you right now, we don't have the authority to do that. I don't think we do. I'll be honest with you.
I'm gonna say we don't.
Huh?
I'm gonna say we don't.
You agree with me then?
I say we don't.
We don't, right.
That's a council decision.
I don't even know if it's a council decision either.
Well,
If it's in the ordinance,
It's in the ordinance, it is what it is.
maybe.
The bottom line is, I think if you wanna do it, they have to suggest, request it in writing, and we can move it forward in the system, whether it's Frank or the council or whomever.
To who?
Again, they can make the request to the board can pass on the request.
Okay.
Maybe if we have another special meeting on this, maybe they can get credited for
I'm not gonna
whatever.
Well,
But,
it may not ever occur, obviously.
yeah, okay.
I'm not gonna make that decision. I'm saying Mr. Gassion should put it in writing what his recommendation is or his request is. And our job is to pass it on. We don't make that decision.
Yeah, send it to me, Bob.
Thank you.
I think Mr. Fiorenzo's approach is what we were discussing in terms of an adjournment with a sorting out via some sort of a letter brief to the board, to me, and coming back at another regular meeting. I think, Bob, you agree with that, Mr. Gaston, you agree with that. The issue that I have that it would be helpful for both of you to brief, I know there is a case that talks about time of application rule, and the ordinance is in effect at the time of the application is filed is what controls. That was a D3 for you. It was not permitted. If what we're hearing is accurate, that has now been changed mid-application to make it a permitted use. There is a case that says if something goes from, if it benefits the client, the applicant, and traditionally going from a not permitted use to a permitted use benefits the client, then you have the right to use the new ordinance. It's only when it goes the other way, where you file and it's permitted, and mid-application is now not permitted, that's not fair, and the court says you continue as a permitted use. So that's an issue that because Mr. Gassion, what you're basically saying is that you want to confer jurisdiction on us when we may not have that jurisdiction under the law any longer.
Again, I researched it this afternoon.
Okay.
But again, it's a moot question. I agree with council.
Well, if you want to stay in front of this board, if it's permitted
But
now,
if I wanted to come in front of this board, I think I had the right to continue the
that's what I need
application.
you to put in writing.
I'm
I'll take a
not
look at
going to put that in writing unless I plan to continue in front of this
it.
board.
I understand.
I'm not going to waste, and I'll let council know.
Can you let us
Can
know
you
that?
both,
Of course.
whatever you send,
I will let
Just
council
give
know
vice
what my decision is. If I'm going to decide to withdraw and appear before the planning board, there's no need for any legal memo from either side, in my opinion.
Agreed.
So,
I agree.
right now,
again,
as we sit here.
just let me finish if I could.
Sure.
Let me go on record. I was not tricking anybody. I was not doing anything surreptitious. I was proceeding under the original application, which I firmly believed I had a right to do. Now that all this has come up and been raised so many times, it obviously creates a potential appeal issue, which I'm not interested in, so I may decide, after consulting with my clients, to go before the planning board. They happen to have an obligation tonight, so I can't consult with them. I'm put in an awkward situation. So,
Speaking of this for myself, I never assumed that you were attempting to pull the wool over anyone's eyes, because the issues that have come up tonight are a treasure trove of issues in terms of land use.
my planner is prepared to testify under the old law that we filed under.
I understand.
So,
That may be a problem moving forward. With jurisdiction.
We disagree legally on that one, but in any event, it may never come up to be an issue.
Great, okay.
So, again, I consent to the adjournment. I will send a letter to Mr. DiLorenzo with regard to the monetary issue involving my client. I will let council know if I'm seeking to proceed with this application in front of this board based on the law at the time of the filing of the application. If not, obviously I'll be filing a new application in front of the planning board, and this board will no longer have jurisdiction.
When do we want to adjourn this to?
Next regularly scheduled meeting.
That's in 2 weeks.
Yes, sir.
Okay, if you feel that's enough time.
What's the date?
The date would be September 5th.
I'll get it resolved in the next day or two, is my opinion.
You don't have to file any new plans or anything, it's just your positions and...
All I need to do is let council and the board know my position. If I'm going to withdraw, obviously I have to refile in front of the planning board.
I think it's easy. If the answer is they're going to withdraw and refile, no big deal. if the answer is that they want to try to continue before this board, my only concern is we have the holiday weekend coming up, whether the 5th is going to give us enough time to submit a legal memorandum to council addressing that issue.
Well, you can argue that on that day. Let's now leave it adjourned to that regularly scheduled meeting.
But are we going to be submitting something for the new meeting in the event you decide you want to press the issue for it? I'm not clear what's happening at
My
that meeting.
suggestion would be, I don't think this board or either of you know if anything's gonna happen on the 5th, other than maybe some decisions as to what we're gonna do. Because there's a couple of pretty heavy legal issues. My suggestion would be carried to the 5th. If there's a major problem, at least we carried it to that date, we can notice again without them having to renotice. If we...
Yeah, why would we have to notice it?
No. If we carry it to the 5th of September and nothing's ready to move forward, we can, on the 5th, announce a new carry date without them having to renotice. We can carry it to the October meeting.
Oh, okay.
If we don't
I'm not going to argue. I think it's a moot point, but certainly it's 2 weeks. There's enough time to prepare if I were to look to proceed. But I expect it's going to be a moot point.
But then he would want to give his legal opinion.
Yeah, I would want, whatever their position is, I'd want to respond to that.
And Mr. Lyon may need time to do some homework
Yeah.
on that too.
Why don't we do it this way? And I'm going to make this simple. Why don't we adjourn this, and you don't have to renotice it, we adjourn it now till October. Let's see, we adjourn it to October. In the event you want to proceed this way, in the event you don't want to proceed this way, all you have to do is withdraw the application and file a new application before the planning board. And you don't even have to come before us in October, September, or any other time.
Let me just check with the one client representative that's here.
Sure.
Okay, Mr. Chairman, we'll adjourn to the October meeting, first Thursday in October.
First Thursday in October. What is the first Thursday in October? Let's get somebody with a calendar here.
I got it, 1 second.
Go ahead.
First Thursday will be October 3rd.
October 3rd.
Yes.
So we're going to adjourn tonight to October 3rd of 2019. For anyone in the audience or in the newspaper, there will be no newspaper notice, and there will be no notice by mail. However, if Mr. Gassion's client decides to withdraw the application from the zoning board, he will then have to file new notice because he'll be going before the planning board.
I understand that.
And I want everybody in the audience to know that. I don't want no surprises, okay? But that's the way we'll do it, and if he withdraws, you'll just get a new notice that it's going before the planning board. If he doesn't, we'll be here on October 3rd.
At 7 p.m. on October 3rd.
Yes, same time, same station.
Extension to October 31st, Halloween, just in case. Extension of time.
Well, let's just make it to that October meeting.
Is that reasonable with you?
Fair to me, Mr. Chairman.
Thank you.
Yeah.
I love when everybody agrees. All right, can I have a motion to adjourn unless there's something else?
Anything else? Okay.
Okay, we agreed, gentlemen? And later,
Any seconds?
second, do I get a second? Mr. Caruso is always the second. Okay. Adjourn.